Wayne, can you hear me?
Hey, I can.
Okay, thank you.
Do you have your keys? Do y'all have your keys?
Literally, I've been working on this file.
Doesn't surprise me.
But now you don't.
Good afternoon.
Afternoon. Right, let's call this afternoon's docket. Who's ready?
I believe Mr. Adams is ready with Mr. Copeland.
All right, Mr. Adams, Mr. Copeland, if you will step up, please. All right, this is cause number CR 23-93 State versus Rusty Wayne Copeland. Mr. Copeland, if you'll raise your right hand, I'm gonna place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thanks, Chief Lawyer. All right, Mr. Copeland, you're before the court today to enter into a plea agreement. You're represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams and the representation he's given to you?
Yes, sir. Yes, sir.
Like you've had enough time to talk with him about all of your cases. There's other cases that he represents you on other than this one. I think he's been representing you for quite some time now. Do you feel like you've had enough time to talk with Mr. Adams about all of your cases and the plea agreement today? You understand everything that you're agreeing to and signing today. Is that correct?
Yes. Yes.
And I've already asked you the other questions, Mr. Copeland. I believe I already know the answers. You've never been diagnosed with a mental condition, correct?
No, sir.
And you are a United States citizen who does read, write, and speak English, correct?
Yes, sir.
Mr. Adams, I'm assuming that you spent quite a lot of time actually with Mr. Copeland going over all of his cases and I guess regarding the plea agreement today, do you believe that Mr. Copeland is competent to enter into that plea agreement, that he is waiving his rights contained therein, and he's doing all of that intentionally, knowingly, and voluntarily?
Yes, Your Honor. Mr. Copeland and I have got to know each other pretty well, and he's competent.
Right, I see that the plea agreement in this cause is that Mr. Copeland would be pleading guilty to prohibited substance or item in a correctional facility. That is a second-degree felony, which does carry a range of punishment, not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. Looks like the plea agreement is that the state recommends to the court that his punishment be assessed at 12 years confinement in TDC. The state is agreeing to abandon the second enhancement paragraph as part of this plea agreement. And the state is also asking the court to take into consideration and dismiss the assault, looks like assault or
It was assault by impeding breathing or circulation, third-degree felony, Your Honor.
says here. Says assault, intent, wreck, breathing, anyway, so the impeding breath or circulation cause for CR 22-7. And I guess Mr. Copeland would be pleading true to the enhancement paragraph 1 in the indictment. In addition, he would be responsible for his court costs, reimbursement fees, and also he would receive 303 days of credit towards the sentence for time that he's already spent in jail on this cause. Is that the correct plea agreement, Mr. Adams?
That's correct, Your Honor.
Mr. Copeland, that's what you understand as well.
Yes, sir.
All right, Mr. Copeland, understanding the range of punishment, understanding the plea agreement. At this time, I would ask you, how do you plead to prohibited substance or item in a correctional facility?
We're guilty, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime and that no one's threatened, forced you, or pressured you to make that decision, correct?
No, sir.
All right, the court will accept Mr. Copeland's plea of guilt to this crime. Mr. Adams, any objection to the stipulation of evidence supporting the plea?
No objection to the stipulation. No.
All right, then, court admits the stipulation of evidence, takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor.
All right, and so with regards to the 1245 of the assault, impeding breath or circulation, is there victim compliance with victim notification on that matter? Is the victim supportive of this plea and the resolution of that case?
I'll double check on that now, Your Honor.
Better off that way.
Your Honor, the victim impact statement was provided to the victim and it was not returned, so the state is in compliance, Your Honor.
Okay, was that done post the trial or was that done before the trial? Because I recall the victim coming in person testifying during the trial, which I believe can't remember how that trial concluded. I don't know if that was a mistrial or what the issue.
Your Honor, it was a separate charge. It ended up in a conviction on a lesser included to a different charge. I don't remember the date of that trial. This was sent out, or the note was entered rather, on February 11th of 2022.
All right, thank you.
Your
Sorry
Honor,
about that. April the 12th.
April of last year of 2023, Your Honor, we had a jury trial of assault, aggravated assault with a deadly weapon, at which the victim in that case did testify. The jury found Mr. Copeland guilty of a Class A misdemeanor, aggravated or assault causing bodily injury. The court sentenced Mr. Copeland to 1 year in the county jail, a $3,000 fine. That left pending cause number CR 22-7, the assault by impeding circulation. And then in this past, about 6 months ago, back in March, the instant offense to which Mr. Copeland signed stipulation of evidence was filed or arose.
All right, great. Thank you, Mr. Adams. I appreciate it. Thank you, Mr. Harwell. All right, court, anything further from the defense, Mr. Adams?
Yes, Your Honor. Mr. Copeland is being given credit for 303 days towards his sentence in CR 2393. That's leaving a lot of back time for him on the field. He's been actually in custody here since November 19 of 2021. I don't know. I believe it's in the court's discretion to grant him that additional back time. And if the court is inclined to do so, we'd be requesting that the court do so. We have the instant plea agreement in place that we have in not an insignificant reason being the effects that how parole might play out with him being sentenced to the prohibited substance charge versus Mr. Copeland being sentenced and convicted for assault by impeding breathing or circulation. In accepting the plea agreement that Mr. Hartwell had conveyed to us and that we've signed up for here today, Mr. Copeland is in effect ceding more than half of the time that he's been in the Van Zandt County Jail to date.
And the court is very familiar. I've dealt with this issue before. I've reviewed the case law, and the court finds that it is unable to grant any kind of credit time that occurred prior to the commission of the offense for which Mr. Copeland is pleading guilty. The court is sentencing him on. The law does not allow the court to grant Mr. Copeland any credit for any time served prior to the date of offense, which is March 7th, 2023. Even if the court did so, the Texas Department of Criminal Justice, through its Board of Pardon and Paroles, would return the case and ask the court for a non-proton, citing that credit cannot be given. Credit cannot be earned or given if Mr. Copeland had not committed the offense at that time. So I've had that issue occur several times. I know that the law does not allow me to do it.
Stood, Your Honor.
Anything further on that, Mr. Adams?
There you go.
I just want to ask you about that other. Is there any way possible that I could get, anything towards my fines on the charge, that I went to court on? There was like 7 months. I got a year and there was 7 months still leaking or backing on the bill. Is there any way that I could get, credit towards my fines and fees on that case?
It looks like the only fees you have are court costs of $290 and reimbursement fees of $20. I don't see any fines. Are you referring?
I think what Mr. Copeland is referring to, Your Honor, is in the case for which we had the jury trial, and he was found guilty of the lesser included offense. The court assessed a $3,000 fine in that case and 1 year in the county jail. Mr. Copeland had 17 months time already. I think he's asking if that the remainder of the 7 months could in any way, shape, or form be used to cut down or cut into the fine amount that he was assessed in the other case.
Thank you. I do. Okay. I appreciate that clarification. Yes, Mr. Copeland, I will grant you relief that you've requested on your fines and fees on that other case. And so I will make that, I will sign an order reflecting that and have that sent out to the jail before you go to TDC.
Thank you, sir. Thank you.
You're welcome. All right, Mr. Hartwell, anything else from the state?
Nothing further, Your Honor. Thank you.
Okay. All right, then, based on the evidence before the court finds that there is sufficient evidence to convict Mr. Copeland of the offense of prohibited substance or item in correctional facility. The court hereby follows the plea agreement, convicts Mr. Copeland of that offense, a second-degree felony, assesses his punishment today at 12 years confinement in the Texas Department of Criminal Justice Institutional Division. Let me back up for just a second here, because Mr. Copeland, I failed to ask you a very important question. The state has alleged in its indictment multiple paragraphs, enhancement paragraphs, increasing the punishment in this matter. They're abandoning their second paragraph, but their first paragraph is remaining. I do have to know and ask you, how do you plead to enhancement paragraph number 1? Is what's contained in that paragraph true or not true?
Yeah, it's true.
Okay. All right. And no one's threatened, forced, or pressured you to plead true to that enhancement?
No.
Okay, thank you. All right, then the court will accept that plea of truth and finds that that plea of truth is freely and voluntarily given. So with that being said, the court does assess the sentence today pursuant to the plea agreement at 12 years confinement, the Texas Department of Criminal Justice. Court finds that the state has abandoned the second enhancement paragraph of the indictment. The court finds enhancement paragraph 1 to be true. And the court does dismiss under section 1245 of the Texas Criminal Code, cause number CR 22-7, the impeding, assault impeding breath or circulation, a third-degree felony. The court does not assess a fine in this matter, does assess court costs of $290, reimbursement fees of $20, and awards Mr. Copeland total jail time credit of 303 days for the time that he has spent in jail on this cause. And Mr. Copeland, while it won't be reflected in this paperwork, the court will grant you relief in the previous conviction, which you served time on the assault. The court will grant the relief of your time served in there against your fines, court costs, and fees. And I'll issue a separate order, as I mentioned before. It's not reflected in this paperwork, but I'll get you some additional paperwork out there that reflects that. All right, Mr. Copeland, you're hereby remanded to the custody of the sheriff, so he can carry out the terms and conditions of the sentence. Step over the deputy, quick fingerprint. Good luck to you, sir.
Judge, I think that's all I have on your docket this afternoon. I'll escape before something happens.
Yes, before something happens. Yes, sir. Thank you, Mr. House.
Thank you, Judge.
Mr. We're ready with Mr. Wood.
Right. All right, this is cause number CR 21-360 State versus Leighton Kane House on a motion to revoke, motion to adjudicate. Go ahead, Mr. Wood.
Good afternoon, Judge. I've been in communication with both the state and the probation department, and it's, I think, in the agreement of everybody to, state's going to essentially withdraw the motion against Mr. House, keep him on probation, Your Honor. I've talked to the probation department. They would like to, and as Mr. House has agreed to, and already signed amendments to put him on 6 months ISP, where he'll be reporting once a week to the probation department. In addition to that, he'll be going to counseling sessions through the probation department, also once a week for 6 months. And so I think it's the right outcome, and I think it's the appropriate way to dispose of this, Your Honor.
Okay. State. See the state. It's probation department there.
Probation department is here, Your Honor.
And is it Ms. Burns?
Yes, sir.
Ms. Burns, is that your understanding and your recommendation to the court on Mr. House?
Yes, sir.
Withdraw the motion and keep Mr. House on. Is there any extension or amendments other than ISB and counseling?
All right, no, sir, that's it.
Okay. I don't think I have any paperwork to reflect any of that, so.
And Your Honor, I don't think a motion, sorry to interrupt. I don't believe a motion's been filed yet. I believe this is a very recent development.
Your Honor, the motion was just presented to me and I just signed it, so I think it's forthcoming.
And when you say motion, what do you mean?
To motion to withdraw, the motion to revoke.
Okay. All right, then the court will grant, once it is presented to the court, the state's motion to withdraw, the motion to revoke. Court will amend the conditions of community supervision for Mr. House to include reporting on the intensive supervision program, and will also amend the counseling requirements as agreed and reflected in the agreement between the state and the defense. Mrs. Burns, is there any additional monetary amendments for arrest, warrant, or anything like that?
No, sir.
Great. All right, Mr. House. I haven't really dug into your case. I haven't even really looked at your case to see what your violations are. I'm not going to do that. I'm going to allow Mr. Wood and the state and the probation department to do their agreement. I'm going to approve it. But you know, you've only got so many opportunities to come before me. And so the next time I will be digging. And if there's any more violations, if you're back in a jumpsuit in front of me, don't be asking to get back on probation, because it's not going to happen. Are we clear?
Yes, sir.
All right. All right, you're free to go.
Thank you, Your Honor.
Thank you, Mr. Wood. Good to see you.
All right, good to see you too. Let the experts get involved in that. That is so.
Good afternoon, Mr. Schmidt.
Hello, Judge.
This is a rare appearance on a Thursday. Feel special.
Yeah, well, me too. You canceled my Tuesday.
Trying to do you a favor
I appreciate it.
on January 2nd.
I'm not complaining too much.
Mr. Creel, you'll come forward. This is cause number CR 23-158. Understanding that we have a plea agreement today. Is that correct, Mr. Schmidt?
That is correct, Judge.
All right, I do have the paperwork here, Mr. Creel. If you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
All right, then you can lower your hand. Mr. Creel, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
Can you tell me about that?
Bipolar 1. I went to Terrell State a couple times.
Has that been recent or has that been in the past?
Once in 21 and once in 22.
So pretty recent. Are you currently on medication or undergoing treatment for those mental health issues? Do you feel like in any way today those mental health issues are impeding your ability to understand what's going on in this proceeding?
Yes, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Feel like you've had enough time to talk with him about your case. You understand all of your legal options and your legal rights. Is that correct?
Yes, sir.
Mr. Schmidt, do you believe Mr. Creel to be competent? And if so, that he's entering into this plea intentionally, knowingly, and voluntarily?
I do believe he is legally competent. I do believe he understands what's going on and is proceeding voluntarily.
Mr. Creel, you are indicted with a second-degree felony offense of aggravated assault with a deadly weapon that does have a range of punishment of not less than 2 years in prison and up to a maximum of 20 years in prison if you were to be convicted and sentenced. I see that the plea agreement in this case is that you would plead guilty to that crime. The state would be recommending that the court review the evidence but not convict you, defer a finding of guilt, place you on 3 years of community supervision, order you to pay a $500 fine, $290 in court costs, $585 in reimbursement fees, that you would be placed on the mental health caseload within the community supervision department, and that the state would be dismissing, looks like 3 unfiled cases regarding criminal trespass, obstruction or retaliation, and also violation of a bond or protective order. Is that your understanding of the plea agreement, Mr. Creel?
Judge, if I may, I do know that Mr. Creel brought up to me that he believed that there was a misdemeanor charge or an additional charge that he was that was pending or unfiled or unindicted that did not make it to the list of cases to be 1245. So while we're talking about it, I don't believe that to be the case, but if the DA's office would double check to make sure that the offenses listed under the police section are all inclusive of his business. Other than that, I apologize for interrupting, but allow him to answer the question. Yes, sir.
I'll give this, Mr. Hartwell, are you going to be researching that?
Yes, Your Honor, and I'm looking at it now. The current cases that we have pending are this case, the violation of bond protective order, a criminal trespass, and the obstruction or retaliation. Those are the only cases we have with Mr. Creel that have not otherwise been resolved.
Thank you. Thank you.
And Mr. Schmidt, does Mr. Creel have some kind of indication of some other charge that's not reflected here? What is it based on?
Judge, I think it was based on earlier communications when he was first released on these charges. I had some communication with the DA's office. There was confusion about whether it was a misdemeanor. I think that the criminal trespass might have been confused as a theft. So that's what we were talking back and forth. I wasn't aware of any other cases, and I've been following his book in, but
he was concerned that there might be, so I wanted to make sure that it was cleared up and that this would resolve all his business.
And Your Honor, I might also, I'm sorry, be able to shed some light. The obstruction or retaliation was originally filed as a terroristic threat. And until we reached this agreement, after looking at it, we had actually changed that charge. So that may be that additional misdemeanor was a misdemeanor terroristic threat that we then, until we reached this resolution, had changed the charge. So that could be the additional misdemeanor.
And that makes sense to me, Judge. Ultimately, the point is that if we proceed, or well, when we proceed, he pleads guilty to the indicted charge, that he'll be going on probation for that charge, and all of his other outstanding business will be resolved. So, you know, he's clear that there's nothing hanging out there that other than what he is pleading guilty to.
Very well.
Yes, sir.
All right, and Mr. Schmidt, have you explained to Mr. Creel the advantages and disadvantages of the deferred adjudication plea?
I have, Judge.
Do you believe he understands that?
I believe he understands it.
All right. So, Mr. Creel, before we go any further, I'm gonna give you a double dose, knowing that Mr. Schmidt has done a fine job of explaining to you your rights, and according to this case, I want to talk about the deferred adjudication. All right. And as Mr. Schmidt's already explained to you, you do understand that if you were placed on community supervision and violate any term or condition of your community supervision, you're not going to have a right to a trial anymore on the issue of aggravated assault with a deadly weapon. That's being dealt with today. Any hearing that you have regarding this case in the future is going to hinge on whether you violated any terms or conditions of your community supervision. You understand that?
Sir.
And the hearing you have will not be in front of a jury. It's going to be in front of me.
Yes, sir.
And as I look through here and I see a multitude of cases that a violation of bond protective order, criminal trespass, obstruction or retaliation. I don't know the facts of those cases. I just see the nature of those cases. And so I'm here to admonish you, which means it's a legal warning that any type of violation of any condition, but especially a condition related to victim safety. I'm assuming that, I don't know if the victim in this aggravated assault deadly weapon case is the same that's in these underlying cases or not. Mr. Schmidt, do you know?
Judge, indeed, the alleged victim is the mother of Mr. Creel. All of the 1245 offenses took place after he was released initially on the initial offense, and there was some confusion in his mind about bond conditions and his living status. So he was invited to go back to that household. He did not realize at the time that it was at least the violation of the bond protective order. Neither he nor the named alleged victim realized that that was a violation. So that's kind of how that spawned. And at the time, we were dealing or attempting to deal with ongoing mental health issues, and hence the requirement that he participate in the mental health caseload, which he is anxious to get started with. He understands he's got his issues, needs to deal with, needs help doing that. So yeah, so that's kind of how that timeline played out.
I appreciate that. That's very helpful. Can you tell me, is there a condition? I don't have the conditions of probation. Is there a similar condition that is going to cause an issue with his residency and placement on probation?
No, sir, I do not see a condition that would be tantamount to what ultimately ended up as a violation of his bond previously. I do know that Mr. Creel intends to submit himself to the Salvation Army, their program in Tyler. I do know also that his transportation back and forth to probation will likely be his mother, who is the named victim here. I don't see any conditions that prohibit that.
All right, thank you. And State, do you have any concerns with that at all? What I don't want to do is set Mr. Creel up for failure if he's going to have a stay away provision against, his residency basically with his mother. Does the state have any position on victim safety or victim concern?
Your Honor, I'm trying to remember. I was looking at it and I didn't see a note for victim contact, but I seem to remember that we did contact the named victim and she was supportive of the plea. I just don't see the note that gives me the details of that.
And
Um,
I'm sorry. I
I'm
did
sorry.
talk to Mr. Hartwell, and that was a condition to this agreement that she approve it. So I do know that after we spoke, he did communicate with her. I don't believe that it's Mr. Crill's intention to reside with her after the plea. Just so everybody's clear. But there will be contact.
And we did, Mr. Schmidt and I did speak in depth about the nature of the conditions to try and make sure that Mr. Creel had the best chance of success, and really crafting it so that he would get the resources that he needs to be successful on probation and to not reoffend.
Thank you. Appreciate both of you. Okay. All right. So, Mr. Creel, I just wanted to be clear, that's giving me clarity. I wanted to be clear so that you could be clear that any violation of your conditions of community supervision, especially anything related to victim safety or victim concern, the court's going to really focus on that. And that any violation could land you in a hearing back in this court, wherein if the court finds that you violated, the court could do a multitude of things, including convicting you of this offense, revoking you off of that probation, and putting you in prison from that minimum 2 all the way up to 20 years in prison. You do understand that. You understand that that's a risk. You're accepting that risk today.
Yes, sir.
Right. All right. So understanding the range of punishment, understanding the advantages and disadvantages of the deferred adjudication plea. Mr. Creel, how do you plead to aggravated assault with a deadly weapon?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty here today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence?
I do not have an objection, Judge. I'm not certain if the court has a copy of the state stipulation before you. Okay. I do know that I discussed the stipulation with Mr. Hartwell. The paper stipulation that I have in my hand, we've interlineated by agreement and initialed. Other than that, we've signed off on the state stipulation.
All right, the court finding there is no objection, the court admits the evidence, the stipulation of evidence, and takes judicial notice of Mr. Creel's judicial confession. Anything further from the state?
Nothing further from the state, and Mr. Schmidt's correct. We have reached an agreed amendment to the previously written stipulation.
All right, thank you, sir. All right, Mr. Schmidt, if you can oblige the court and just read the stipulation of evidence into the record.
Yes, sir. On or about July 27, 2022 in Van Zandt County, I, Brandon Creel, was released from Terrell State Hospital, went to my mother's home. While I was there, I got into an argument with her and threatened to kill her with a hammer.
Thank you, Mr. Schmidt.
Yes, sir.
Is there anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that there is sufficient evidence to convict Mr. Creel of this offense. The court will follow the plea agreement based on the recommendation of the state. Court hereby defers a finding of guilt, places Mr. Creel on 3 years community supervision on the offense of aggravated assault with a deadly weapon and second-degree felony. Orders him to pay a $500 fine, $290 in court costs, $585 in reimbursement fees. Court orders him as a special condition of community supervision to be placed on a mental health caseload. The court does dismiss under section 1245, cause unfiled DA numbers 2023-15 in violation of bond and protective order, DA 2023-408 criminal trespass, and DA 2023-409 obstruction or retaliation. Mr. Creel, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy and go get fingerprinted, and then the probation officer will give you some more information. What else do you have, Mr. Schmidt?
Jason Bearden.
Have it, please. Said Bearden. Oh, there he is.
Yes, sir.
Whatever reason. Oh, yeah. We got it. I'm staying differently. All right, this is Mr. Bearden. Come on up. This is cause number CR 21-278, State versus Jason Kobe Bearden. Motion to revoke, motion to adjudicate. Go ahead, Mr. Schmidt.
Judge, I've conferred with Mr. Hartwell and Ms. Burns with the probation department. Mr. Bearden, he was arrested in McLennan County. McLennan County is trying to put him in their Veterans Court program to address some of the issues he has ongoing. Mr. Hartwell and I have conferred. The state, I believe, is going to file a motion to withdraw and continue. Ms. Burns discussed that with her. She's going to agree from the perspective of the probation department, amend his conditions to include additional attorney's fees for representation in this matter, as well as transferring his probation to McLennan County and his active participation in their Veterans Court program as a condition of his community supervision.
And Your Honor, I did file a motion to withdraw the motion to adjudicate in November of 2023. So that should already be e-filed and just awaiting final decision. But yes, that my understanding is the motion to adjudicate was primarily based off of a new offense happening in McLennan County, and McLennan their plan was to put Mr. Bearden on Veterans Court due to that new offense. And I see no reason why he shouldn't have that opportunity since it was a McLennan County offense.
And Judge, I know that our probation department was reluctant to give their stamp of approval on that. I've talked to Ms. Burns and they have agreed to that, obviously with the stipulations of the amendment to those conditions that he participate in their program and successfully complete it. Also, I would like to note for the court's attention that the state's MTA notes this as a third-degree felony. It's actually the judgment of the state jail felony, just so that we're clear on that. But we would ask that the court extend him. Oh. On this Veterans Court program.
60 days for the program. I think it's not
6 months. 6 months. We're going to agree to extend the period of his community supervision for an additional 6 months, Judge. Thank you, Tom.
All right, so it's a withdrawal. It's extend 6 months, transfer to McLennan County,
Yes, sir.
and it is amended to include. Is Mr. Bearden already entered into their veteran court program, or is he trying to get in?
Judge, this particular motion is what's preventing him from getting into it, but I've spoken to the folks in McLennan County. I believe the DA's office has as well. They were waiting on us to resolve our business so that he could do that. And it's my understanding once he's done here, he'll be transferred back to McLennan County, and they will get him in that program.
So if we make it a condition, it's something that's going to happen. It's not going to be problematic.
Yes, sir.
Okay, Ms. Burns, you agree with all of those? Anything else we need to do?
No, sir. Yes, sir, and no, sir.
Yes, sir. No, sir. Okay. All right, then the court grants the state's motion to withdraw the motion to revoke. The court will approve the agreement to amend the conditions of community supervision for Mr. Bearden to extend his supervision period for an additional 6 months. The court will grant the transfer of his community supervision to McLennan County. The court will make as a condition of community supervision that he successfully complete their veterans program as ordered by the McLennan County.
Thank you, sir.
All right, thank you, Mr. Bearden. Good luck, sir.
Thank you, sir. And then they're gonna.
Mr. Hartwell, I will print out the motion that you filed in November. I'll print that out and I'll sign the order attached to that. No need to follow.
Thank you, Your Honor.
All right, Mr. Manning, who are you ready to sir?
Judge, we're ready on the plea for Mr. Britton.
Jimmy Don Britton, cause number CR 23-204. Mr. Britton, sir, if you'll raise your right hand, I'm gonna place you under oath. Mr. Britton, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, good, put your hand down. Mr. Britton, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you understand everything that you've read and signed as part of your plea agreement today?
Yes, sir.
Is there anything that you don't understand?
No, sir.
Mr. Manning, do you believe your client to be competent? And if so, have you explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
Judge, he is competent. I have explained the pros and cons of deferred adjudication as well as the range of punishment on this offense if he's unsuccessful.
Thank you, Mr. Manning. Mr. Britton, you are charged with a third-degree felony offense of injury to a child, elderly, or disabled individual. Bodily injury that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and can carry a fine up to $10,000 if you were to be convicted and sentenced in this case. I see that the plea agreement is that you would plead guilty to that crime. The state's recommending that based on your plea of guilt, court should defer a finding of guilt, meaning the court should not convict you today. They're recommending that I place you on community supervision or probation, as it's usually known, for 10 years in order you to pay restitution of $500 plus court costs, reimbursement fees. And as a special condition of community supervision, you're not to have any contact with the child that's the victim of this matter until probation approves it. You would also have to take anger management and also parenting class. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the plea agreement, understanding the range of punishment, I also want to admonish you that should you violate your conditions of community supervision, the court could conduct a hearing, allow the state to put on their evidence. If the state proves you violated a single count of your community supervision, the court may have the opportunity to do a number of things, including convicting you of this offense, which would make you a convicted felon. The court could revoke your community supervision. The court could assess your punishment anywhere from that minimum 2 to that maximum of 10 years in prison. So you understand that risk, correct?
Yes, sir.
Right, understanding all that, do you still wish to proceed?
Yes, sir.
All right, Mr. Britton, how do you plead to injury to a child with bodily injury, a third-degree felony? Sorry, I didn't hear you.
Guilty.
And Mr. Britton, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, force, or pressured you to plead guilty?
No, sir.
All right, the court will accept Mr. Britton's plea of guilt at this time. Mr. Manning, any objection to the stipulation supporting the plea?
No objection to states one.
All right, states one, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor, a victim impact statement was returned. In this case, I believe it has been forwarded to the court. I just want to make sure that that you've had an opportunity to review that. Otherwise, we've been in contact with the victim as far as going forward with this plea today, and she is in agreement.
All right, thank you, Mr. Hartwell. The victim impact statement is here. I've not had a chance to review that. I will review that prior to the voting sentence in this case. I appreciate.
Thank you.
I appreciate the response on the victim agreement with this plea.
Yes, sir.
Mr. Manning, anything further from the defense?
Nothing from defense, judge.
All right, court's going to take a moment to review the victim impact statement, and then after which, Mr. Manning, I'm going to ask that you assist the court by reading the stipulation of evidence. Just one moment. All right, the court has reviewed the victim impact statement. I will sign that and return it to the DA's office for processing, Mr. Harwell. Good, Mr. Rainey, if you can read the stipulation of evidence in the record.
On or about September 2nd, 2023 in Van Zandt County, I, Jimmy Don Britton III, was watching my 11-month-old son. I got his foot stuck in his crib. I was already frustrated by something else I had going on. I was further frustrated by the situation, so I wrenched my son's leg out of the crib, twisting it when I heard it pop. As a result, my son's leg had a fracture. When investigators spoke to me about it, I was hesitant, but did admit to everything.
Thank you, Mr. Rainey. Anything further from defense? Son?
Nothing from defense.
Anything further from state?
Nothing further, Your Honor.
All right, then based on the evidence for the court finds that there is sufficient evidence to convict defendant of this offense. Court will defer a finding of guilt follows the plea agreement today. On the offense of injury to a child, a third-degree felony, the court defers finding of guilt, places Mr. Britton on 10 years community supervision, orders him to pay $500 in restitution, $290 in court costs, $520 in reimbursement fees. Furthermore, the court will place will place him on special conditions of community supervision to include no unsupervised contact with the child until the probation department approves it. Unless otherwise overruled by a court order in a custody case denying him access. Overruling. I'm not sure what does this mean. It says special conditions of probation to include no unsupervised contact with the child unless the probation department approves it. Parentheses, but any court order in the custody case denying him access. What does that mean?
Does we take that to mean that the probation department can't give him permission to do something that a court order in the custody case has prohibited him from doing? I've explained that to my client. He understands that if there is a separate court order from a family law case that prohibits him, that even if the probation department gives him permission, he would not be able to have unsupervised contact.
All right, the court will make that a special condition of probation. Court also makes a special condition of probation, anger management, and a guarantee clause. Mr. Britton, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted, and then the probation officers will give you more information.
Judge, I believe that concludes my business. Might be excused.
Yes, thank you, Mr. Rainey.
Thank you, Judge.
Okay, Ms. Taberingham, I did have a chance to read. I saw Mr. Trainer pop into the,
Oh, okay, we didn't know.
let's see. Is Mr. Butler there?
Yes, sir.
Okay, let me go ahead and bring Mr. Trainer.
No, not even.
All right, good afternoon, Mr. Trainer.
Hey, Your Honor, how you doing?
Doing great. This is cause number CR 22-62, State of Texas versus Corey James Butler. And I believe we had this case. We've been setting on status for quite a while now. And then I think there was some confusion, probably just on behalf of the court, regarding status of who counseled this for Mr. Butler. I know you appeared, and then Mr. Millsley was also appeared. There was some discussions back and forth. And so anyway, you're here today. I'm assuming, Mr. Trainer, that you are still attorney of record for Mr. Butler. Austin. Maybe he's not your attorney anymore, Mr. Butler.
I don't know what I'm paying these guys for.
What'd you say?
I don't know what I'm paying these guys for.
Huh. They need to invest in better cell service. He probably just lost cell service. Let's give him a second to log back in. Square away. Butler, I don't know how long it's gonna be for the log back in, so if you wanna have a seat, that way you don't have to stand there the whole time. You're welcome to do so. I'll stand and I'll maybe handle another case. Do we have anything else to say right now?
And we just need to make an announcement on Jennifer Zanella.
Okay, let's do that. This is cause number CR 23-133. CR 23-156, CR 23-157, State of Texas versus Jennifer Paulina Zanella. Miss Zanella was set for arraignment today. She was in the custody of Benton County Sheriff's Office, believed had to seek medical attention today. Was Miss Zanella admitted into the hospital?
They've not decided yet. She is still in Tyler, but no decision has been made yet. At last I heard.
It's my understanding that she was transported, and so if we anticipated there would be no decision made on whether or not she was going to be admitted into the hospital for her medical issue. The court went ahead and contacted the attorney of record, Mr. Alvaro Aguirre. And we told Mr. Aguirre that we were set for arraignment today, and we advised him of his client's medical issues. Advised him he didn't need to appear because we knew that she wasn't going to be able to appear while seeking medical attention. So we have reset. I think we have reset that. Did you already give them a new date of 1/18? I think. Is that right?
Yes, sir. January 18th at 1:30 unless she was released.
All right. So the court will set Miss Zanella for arraignment on January 18th at 1:30. If she's released, it'll be at 9 a.m. that day. All right, we'll stand in recess until Mr. Trainer walks back in. I'll just stay here on the bench until that. All right, Mr. Trainer, do you have bad reception in there?
Yeah, my phone died, Your Honor, so I just had to come down here and get a charger. I'm so sorry. I'm in two district courts at the same time, so apologize.
No problem, understand. All right, let me re-announce what we're doing here. This is Mr. Butler's case, CR 22-62. We had Mr. Butler set for status a number of times, and correct me if I'm wrong, Mr. Butler, you were in federal custody. You're still in federal custody, is that correct?
Yes, technically, I mean, I'm not, because my time is to be run consecutive, but I was.
Okay. And so we had reset Mr. Butler's case numerous times to see what was going to happen on the federal prosecution. And then Mr. Millsagel has made an appearance in this case. Mr. Trainer, you've made an appearance in this case. I was kind of confused as to who counsel was for Mr. Butler. Obviously didn't engage talking with him about that. So any announcements, Mr. Trainer, on Mr. Butler's case right as we stand?
Yes, Your Honor. As he was stating, he's actually it was our impression that he had paid Millsagel to go ahead and take over this case here, and I guess there was confusion on whether or not the federal case or this case that he was taking over on. I've tried to reach out to his office to try to get some clarification there, but it was over the holidays. I guess their office had been shut down. There was I sent emails and made phone calls and haven't gotten anybody on the telephone yet in regards to that. But I mean, I'm more than willing to go ahead and help him on this case. I'm the attorney of record as it stands right now.
Have you had a chance to talk to Mr. Butler about the case and about y'all's attorney-client relationship? Have you ever had a chance to do that?
Yes, Your Honor.
All right. And so, Mr. Butler, can you clear up any confusion for the court? Do you intend that Mr. Trainer be your attorney in this case, or Mr. Millsagel?
Like Mark said, I originally, when I got done with federal, Matt was my attorney there. When I got here, he told me there that they were deciding to run with some charges here. So when I got to Van Zandt County, I called Matt and I asked him to represent me in the case. I guess there was a misdemeanor and a felony. I thought they were both felonies. So I guess he was under the impression that he was only representing me for the felony. I thought he was representing me for an escape charge. And so there's been some confusion there. I don't know. I don't really know what's going on. I haven't got to speak to him again about the cases or anything. So I don't really know. I've been in contact with Trainer since. And I mean, whatever we need to do to get this taken care of.
Yeah, so Mr. Trainer, I see that the case that Mr. Butler's indicted on is a possession of controlled substance, penalty group 2, 1 to 4. Is that where you were retained on and what you filed your letter of rep on? Mr. Trainer, did you hear what I said?
On again.
No, you're still there, Mr. Trainer. I can hear you. You just gotta turn your ear. Let me prompt you to turn on your. If you'll hit that prompt, I just sent you. Mr. Trainer, are you still with us? Still showing to be connected. Mr. Trainer, you still with us?
Sorry, Your Honor.
Okay, all right, so what I was asking, Mr. Trainer, is you were retained on the possession of controlled substance from Mr. Butler, correct?
Yes, Your Honor.
Okay. And Mr. Butler, you're indicating that you think that there's additional charges pending here?
I had an escape, a misdemeanor escape as well. Which I didn't even know was a misdemeanor until just a few weeks ago.
And you're saying that you reached out to Mr. Matt Millsable to represent you on that misdemeanor escape?
Assuming it was a felony. Nobody ever told me that it was a misdemeanor, and so when I contacted him, he told me in Henderson County they were running with the escape charge, and that was all I'd gotten booked in on. And so I thought it was the felony escape charge, and that was all that was in the computer when I got here. And then October, I think the 6th of 23, that possession charge showed back up in the computer. So I guess Matt just looked on the computer whenever I talked to him on the phone and just pulled up the felony and said, okay, I'll represent you on the felony. So there was just some kind of miscommunication.
But did you say Henderson County?
Yes, sir. When I was in Henderson County for the federal hold, I was being held. I was waiting to catch a chain down to the BOP. That was when I originally spoke to him, and he was also my federal lawyer. So he's pretty familiar.
Did you say the escape charge originated out of Van Zandt?
It did.
I'm not seeing any kind of escape charge. The only thing that I see.
Yeah, I've been going to court on both of them back and forth, and there's been no communication between the two.
Which court have you been going to on the escape?
I went to court for the escape charge. I was assuming it was arraignment or something. About 2 weeks into being here, I got here about September 15th, 23. And about 2 weeks, I went to court, and the judge asked me if I knew what I was here for, and I told him, yes, sir, the escape charge. And he said, that's correct. But that's all he had said. So I'm really confused on the whole situation. So
Your Honor,
Yes, sir, go ahead.
if I may, maybe I can clarify matters. The PCS charge as it currently stands and filed has been indicted. There is an additional felony escape charge that has not been indicted, that I think that stemmed from the same series of incidents that brought him into the court's attention and jurisdiction. So that may be the miscommunication, in that there is a felony escape pending that has not been indicted, that also arose out of this PCS charge. So for that reason alone, I'd like to have the opportunity to speak with Mr. Trainer. He called and left me a message yesterday on the phone. I tried to get a hold of him, but wasn't able to, in order to have maybe a conversation regarding if a disposition can be reached.
Would y'all like the opportunity to get in a breakout room right now and be able to talk?
I honestly think it's probably going to take a little more than that, Your Honor, just to go through that. So if we may reset it one more time, I think now that I know I can get in touch with Mr. Trainer, I'd be happy to try and put this to the front of the line, so to speak, so that we can get it off the court's docket.
Yeah, I'm fine with that. I just wanted to first establish, is Mr. Trainer counsel for Mr. Butler? And
Yes.
I mean, that's what I'm showing is the letter of rep from Mr. Trainer back in 2022. So if Mr. Millsagel is not attorney of record, then moving forward, I will reset Mr. Butler for an additional 30 days, give you all a chance, Mr. Trainer, to talk with Mr. Hernandez in his office and see, go ahead and get that worked out.
Yes, Your Honor.
All right, so can you have your calendar available, Mr. Trainer?
Yes.
All right, I've got some reset dates in February that I've been setting on. Got February 13th, February 15th, February 27th. One of those three dates better for you?
No, all three of those are after Your Honor.
All three in the afternoon? Yes, all three will be in the afternoon, because the court here, I hear all of my jail cases in the afternoon.
Okay, yeah, and I do know that I'm not sure if it's either one. I do have one starting on the 13th. So I'd just be on the safe side if we can do the 27th. Be able to play the 27th at 1:30.
Yes, sir. Okay. All right. The court will set Mr. Butler for, go back and see. I'm not even sure that. Sure. Let's see.
Mr. Hernandez, what is, your email, what's your first name? Still there?
Yes, hang on, Mr. Trainer. Let's see, we started having hearings in this case in April of 22. Says arraignment, and we went to pre-trial, and then we went into federal custody. So I think we're already past arraignment and pre-trial, but I'll tell you what, just because it's been a while, let's just go ahead and set Mr. Butler for pre-trial hearing. That way, if there's any contested pre-trial motions, they can be filed and ruled on. And we'll set that on February 27th at 1:30. Did you get all that, Mr. Trainer?
Yes, sir.
Okay. All right. Thank you, Mr. Hernandez. I appreciate you clarifying that for the board. Mr. Butler, do you have any questions, any concerns, or anything we need to take up?
No, sir.
Okay. All right. Then we'll see all of you back on February 27th. And I trust that, Mr. Trainer, you'll get with the DA's office, see what you can get worked out for Mr. Butler.
Perfect. Thank you, Your Honor.
All right. Thank you, Mr. Trainer. All right. If there's nothing further, then we're adjourned in this case.
This all the holding.
Maybe, Your Honor.
Yes. Thank you, Mr. Trainer. Appreciate it. All right, Mr. Secretary.
All right, we'll see you in a few minutes.
All right. Thank you.
Thank
All
you.
right, that concludes this court's criminal docket for this afternoon. Court is adjourned.